Griggs, let me know if I'm live on YouTube.
This meeting is now streaming live on YouTube.
Okay. All right, Mr. Griggs, if you could just announce the name of the case and the cause number.
We're here today on cause number DC 19-07345, Ralph McElroy plaintiff versus Joe Lee Robinson, Gilbert Jackson, and Alter Anderson defendants.
Okay, just to kind of summarize where we are, this case was called to trial this morning. There was some issues that needed to be worked out with Mr. Chambers and the other folks in the case. So we reconvened at 3:30. My court reporter, unfortunately, is having some technical difficulties in terms of working with her equipment. I'm not sure exactly what's going on. This is not a usual thing. So we've decided to do this on YouTube and then allow Ms. Rieger to go back and transcribe this if it's needed off the YouTube. Is that agreeable to you, Mr. Chambers?
Yes, sir.
Is that agreeable to you, Mr. Griggs?
Yes, it is. Thank you.
And Gilbert, I forgot your last name. If you need to unmute, sir. You need to unmute.
Okay, can you hear me?
Yeah. Is that agreeable to you, sir?
Yes.
Okay. So what we're doing here now is a prove up of the settlement in this case. Mr. Griggs, why don't you take over?
Thank you, Your Honor. This is a case that involves a dispute over ownership of two undeveloped residential lots in Seagoville, Texas. The indication is from the Dallas Central Appraisal District that there were three owners of this property. I was asked to represent the third owner, Alter, A-L-T-E-R, Anderson, who I have tried to find through my normal process of leaving voice messages, computer research, other types of search features. I was not able to find any living heirs directly here of Mr. Anderson. However, in fact, I did file an attorney ad litem report with the court a few weeks ago. Since that time, I will indicate that I have determined that a woman named Eva, EVA Anderson, apparently lived at the same residence with Mr. Alter Anderson. She paid the property taxes for a few of those years before apparently Mr. Anderson passed away, and has paid them as late as 2005, which I believe was after Mr. Alter Anderson was deceased. So, Your Honor, at this time, I don't have, and she has since passed away, I believe. So there are no living heirs at the moment that I can find of Mr. Alter Anderson. However, I do believe that other evidence that Mr. Chambers may be presenting on behalf of his client might shed additional light on what's happened since that time.
Okay. Mr. Chambers?
Thank you, Your Honor. My name is St. James Chambers. I represent the plaintiff, Ralph McElroy. First of all, I'd like to ask the court, was the court able to receive my e-filing that was submitted today? I sent in a proposed judgment and a few exhibits.
Did you e-file that today?
Yes.
You did? Okay. Rhonda, can you email that to me?
Your Honor, I believe that it was accepted for file because I was able to read it myself.
Oh, it's online. Okay, I'll pull it up.
Gilbert, were you able to also get those documents?
Documents?
I e-filed some documents that I saw you had you were registered with the e-file system.
hmm
this morning, and you should have gotten an email where you could view those documents.
Oh, yeah, I seen a few of them, some of them.
Okay, well, I'm getting ready to kind of review those with the court. So a lot of them involve you, so I just want to make sure that.
You said you could pull them up.
Well, I received,
Oh,
Your
here's
Honor, a notice that they had been accepted, and so well, let me see. Was it acceptance? Nope, sorry, Your Honor. It was notification of service, is what I received. But
Okay.
they're attached, so I can read them.
I have, you can see them.
Right. It's basically a proposed judgment order with 5 or 6 exhibits.
Okay. They're not online, unfortunately, that I can see. I do have your attorney ad litem fees order.
Oh, Your Honor, I've got it right here. I'm happy to email it to you immediately if you'll give me
You want
an
to email it or you just want to share? Oh, wait a minute.
It's on my phone. I'd have to email it, sir.
Yeah, I can email them to Rhonda.
Let me see.
Rhonda, yeah.
Well, I have it ready to go. So if somebody will give me an email, I'll happily send it.
Yeah, we just have your stuff. Yeah, go ahead and email it to Rhonda. It's rhonda.pinson@dallascounty.org.
And that's PIN.
Yeah, PINSON.
Okay, Rhonda.Pinson@Dallas Courts.
Dallas County.
Okay. Rod.Pinson, PINSON@DallasCounty.org.
Yes.
Okay. It's on its way to Rhonda.
Okay. Go ahead and Rhonda forward that to me and go ahead and go forward, Mr. Chambers.
Yeah, I have it. I have it.
Go ahead.
Okay, you go ahead. Well, Judge, as Mr. Griggs was stating, initially this was a lawsuit to try title. As the case evolved, we somewhat discovered the record owners of these. It's 2 lots. I'm calling them lots 100 and lots 101. Records, property records in Dallas County reflected these 3 persons as equal owners of 1/3 of Joe Lee Robinson, Gilbert Jackson, and Alter Anderson. As Mr. Griggs was stating, well, first of all, I'm gonna deal with the defendant Joe Lee Robinson. Once you get the exhibits, it reflects that Joe Lee Robinson became deceased in December 18th of 2013. Further investigation showed that Joe Lee Robinson was married to Betty Robinson, who is surviving spouse, and she's still alive. And Exhibit B is an affidavit from Miss Betty Robinson, recently notarized, where Miss Robinson basically stated that she's a living spouse of Joe Lee Robinson, and she doesn't want to be involved in this lawsuit, but is aware of it. Since then, Betty Robinson and my client has settled in a dispute that might have been regarding.
Is this what you're talking about, the verification of death?
That's Exhibit A, yes.
All right.
Exhibit B is an affidavit from Ms. Betty Robinson.
Okay, let me see if I can pull that up. All right, so Exhibit A is being offered into evidence. Any objection, Mr. Griggs?
No objection.
Exhibit A is admitted.
Do you have an objection, Mr. Jackson, Mr. Gilbert Jackson?
Oh, Mr.
No.
Jackson, do you?
No,
Exhibit B is admitted. Can you guys see, I'm sorry, exhibit, any objection to exhibit B?
No objection, Your Honor.
Mr. Gilbert,
no,
Jackson, okay. All right,
Now, Exhibit C, which you don't have, was rejected by the e-filing system.
okay.
And I can send that to you if you must have it, but in short, Exhibit C is a deed executed by Miss Eva Robinson in 1985. You don't have that. I can email it to you quickly if you like, but just to speak of it. In the 1985 deed, Miss Anderson deeded a third interest in these lots. When she kept the third, she deeded a third to Jolie Robinson, and she deeded a third to I'm
Gilbert.
sorry, I'm getting a little confused. He's not Gilbert, but her husband at that time, Eva Anderson and Arthur Anderson, she deeded a third to Arthur Anderson, Jolie Robinson, and a third to herself.
Is this the will you're talking about here?
No, I'm get that next. I'm talking about the deed that was rejected. I don't know, but it was rejected by the e-filing system. But that's out of property.
Mr. Griggs, do you have a copy of the deed?
No, I don't, Your Honor. That's letter C that apparently was rejected. I do not have that.
Do you have a copy of it at all?
I can send it to you, Judge, right quick.
Go ahead and email Rhonda that.
Okay. But I'm just, I can just talk about it, then move on and try to. So, okay, Exhibit D is proof of death or the date of death of Arthur Anderson.
Here?
Yeah.
Any objection to exhibit D?
No objection.
no,
Okay,
no objection.
So I can call Gilbert Jackson. When I call Mr. Jackson to the stand, I anticipate that he's going to say that Arthur Anderson and Eva Anderson were husband and wife, and that Arthur predeceased Eva in death, and therefore whatever Arthur owned went to her because they had no children. And that's what I anticipate Jackson to say. I also anticipate Mr. Jackson to say that Eva Anderson was his aunt, and that she died, and that she died and left a will. I also anticipate Mr. Jackson to say that in the will, in Eva Anderson's will, he was the sole heir that was named in the will of Eva Anderson. And Exhibit E is Eva Anderson's will.
okay. Someone has a TV in the background. Could you mind turning that off? Because it's kind of hard to hear.
And I offer that into evidence.
All right.
I also
Any objection to exhibit E, Mr. Griggs?
No, no,
No objection,
Jackson?
Your Honor.
no,
Mr. Jackson, okay.
no,
I also anticipate Mr. Jackson's testimony to say that Exhibit F is a document that he had an attorney prepare and file with the probate court as Eva Anderson's will as a muniment of title, which allows him to dispose of any real property that Eva Anderson may have owned.
Any objection to exhibit F?
no,
No objection, Your Honor.
Exhibit F is admitted.
Also, go down to Exhibit G, which is an affidavit of defendant Gilbert Jackson that he recently signed before a notary, contending that he and Mr. Muckleroy have reached an agreement regarding the disputes of this property. However, the only concern is when Mr. Jackson put in his muniment of title, he did have Eva Jackson's name removed from these two lots, but not Arthur Anderson. So we're asking the court to recognize that Gilbert Jackson owns not 1/3 of these two lots, but 2/3 or 66% of these two lots. Whatever percentage he owns, he's settled with Mr. Muckleroy and asking the court to allow him the power to convey or transfer whatever interest he has in those lots.
Any objection to Exhibit G?
No objection.
No.
Exhibit G is admitted.
Now, Judge, I can take a break and forward to you to Exhibit C, or I can call Mr. Jackson.
Why don't you just email that real quick so I can get it and we can make sure we have a complete record?
About 2 minutes. Okay, Exhibit C has been sent to Rhonda.
Okay, Rhonda, go ahead and forward it to me. You can go ahead and call Mr. Jackson.
Mr. Jackson, I'll call you to stand.
Okay.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, Mr. Chambers, you may proceed.
Okay, Mr. Jackson, you've heard the representations I've done to the court regarding your actions in this manner.
Yes.
Okay, you're the named defendant in this case, correct?
Yes.
Okay, and is your belief that tell the court, I've represented to the court that Eva Anderson is where you received your interest from this property through her will and your filing of muniment of title in the probate court. With me? Is the correct?
Yes.
And the affidavit Exhibit G, you signed that freely and willing?
Yes.
And that you, Mr. Muckleroy, have reached a monetary settlement regarding any interest you may have
Yes.
in these two lots?
Yes.
Is it your contention that you own not 1/3 as the property records reflect, but 2/3 of both of these lots?
Yes.
And are you satisfied with the settlement in this case?
Yes.
I'll pass it.
Mr. Griggs?
Yes, Mr. Jackson, I only have really one question for you, and that's just for you to verify this. Evidence has shown, and some of my research has indicated, that Eva Anderson was in fact married to Alter Anderson. Is that your testimony?
Yes.
No,
Yes.
no other questions, Your Honor.
Oh, Gilbert, you're asking the judge to allow you to be able to convey, like I was saying, your interest if the court finds that you do own 2/3 of these 2 lots.
Yes.
This will be able to convey them, even though at least 1/3 of each of those lots don't reflect your name, they reflect Arthur Anderson's name.
Okay. Yeah, I understand.
All right. Let me hear any other questions for Mr. Gilbert. Did you want to provide any other testimony, Mr. Jackson?
No, Judge. I appreciate it. No, none at all.
Mr. Griggs, have you had an opportunity to look at the judgment here?
Yes, I have, Your Honor.
Do you have any objection to it, or does it need to be corrected?
Other than the ad litem fee has not been entered into it yet, but we do have an agreement that was in a separate order that I filed this morning with the court.
And that's going to be paid by Ralph Muckleroy, is that right?
Yes, sir.
Okay. All right.
Judge, I would like to call Mr. McElroy for once.
Okay. Mr. McElroy, please raise your right hand. Do you swear or affirm the testimony about to give shall be the truth, the whole truth, and nothing but the truth? I can't hear him.
Say it again.
I heard that. Leave it right where it was.
Okay, Mr. McElroy, you understand everything that happened here today?
Yes, I understand.
Okay, and anything else you would like to add?
Yo, I'm satisfied with what I heard.
Okay, now, as far as the ad litem attorney fees, you and Mr. Griggs have reached an agreement to that amount?
Yes, we have.
Okay, and is that $900?
Yes, sir.
Okay, now, when will you be able to forward that $900, or how would you like to pay Mr. Griggs those funds?
I will pay him.
The full amount? Are you gonna pay him through me, or how are you gonna pay him?
I can pay it either way. It don't matter. Through you, be fine.
Okay. I don't usually need this on the record unless Mr. Griggs wants it.
Oh, I'm sorry, I didn't know.
Is that okay? You need it on the record? Mr.
That's
Griggs?
fine, Your Honor. I was on a conference call with him yesterday, and I believe he will follow through. So I'm satisfied. Thank you.
All right. Mr. Griggs, did you have any questions? Mr. McElroy?
I do not.
Yes, sir.
Mr. Jackson, do you have any questions of Mr. McElroy?
Not at all, Judge.
Okay. All right. The court is going to grant judgment as requested. I'm going to pay the attorney ad litem fees. They're going to be ordered to be paid by Mr. McElroy to Mr. Griggs. I'm glad we finally got this done, and that will conclude the hearing. Thank you so much, guys. You guys have a great day. I'm glad this all finally worked out. Okay.
Thank
Thank you.
Thanks,
Thank
Your Honor.
You guys be
Appreciate
safe
it.
out there.
Thank you, Your Honor.
All right. And Tony, if you have any questions about where to find the YouTube link, let me know.